Hi, y'all. It is called permanent residency, but it is not always permanent. And I am going to be talking to you today about how you may end up losing your green card after, right? After you have worked so hard to get it, you don't want to lose it. So let's talk about ways that you could lose your green card and what you can do to make sure you do not fall into these things. I am U.S. immigration attorney Lillian Chukura, and I help my clients get their green card and citizenships for themselves and their families using the U.S. immigration law system. So, like I said, we'll be talking about how to actually keep your green card. You worked hard to get it. I've been talking to you about different ways that you can get a green card. And today we're going to be talking about how you get to keep it. Okay. What things you can do to make sure that you keep it and USCIS does not take it away from you. Hi, Pedro. Thank you for joining. Hi, Casmita. Thank you for joining. If you are joining me, make sure to say hi. Tell me where you're joining me from. If you do have immigration questions, feel free to put it in the comments. If you're watching on the replay, welcome. Put your questions in the comments as well. I do go back and respond to those. Now, let's get started. The number one thing that a lot of people do this, that ends up causing someone to lose their green card is living outside of the US, right? Being outside of the US for too long can cause you to lose your green card. And if you don't know this, I hope now you know. Hi, Pedro from Maryland and Paulette from Trinidad. Thank you for joining me. I just hope you get value out of this video. If you have questions, remember, put them in the comments. Now, being outside of the US for too long can cause you to lose your green card. It's called permanent residency because you are basically telling the US government that you want to permanently live in the US. And if you're doing things that cause them to believe that you don't actually plan on living in the US, they can then take your green card away. So living outside of the US, so for example, going back to your home country, buying a house, then living there for like a year, getting a job over there, doing things that makes it seem to USCIS and the government that you actually want to go back home. You don't plan on staying in the US and making the US your home. Those are things that can lead to you losing your green card. If you are outside of the US for 6 months or more, just make sure you have documentation showing that you still maintained a residence in the US, that you still had employment, family, you are paying your taxes, you're filing your taxes, things like that to show that you still plan for the US to be your home. It's just you had an extended stay outside of the US. If you're not able to show this and you get to the airport, the officer that you meet at the airport may decide to make it a big deal and do one of two things. They can let you come back into the US, but put you in removal proceedings to try and take your green card away. Or they can turn you back, say that you are no longer a permanent resident because you stayed outside of the US for too long. In those situations, you may need an SB1 visa, which is a returning resident visa. You don't want to get to that point because some embassies do not like it. Their procedure for getting it is really hard. So you want to make sure that you are not staying outside of the US for so long that you will need a returning resident visa. If you do know, right, if you know that you're going to be outside of the US for a year or more, what you can do is apply for um, a permit basically that allows you to leave the US, stay there for up to 2 years, come back in without it affecting your actual residency. That's really the key here. You want to make sure that you're taking steps that makes it so that you do not lose that green card. Okay. So if you are, for example, like I said, leaving for a year, you're planning on staying outside of the US for a year, but you're not really sure. right? You're not sure if you're going to be staying a full year or more. So what you can do is apply for a re-entry permit. A re-entry permit gives you up to 2 years outside of the US. So if you have to, travel outside of the country because you had businesses that you need to figure out and finalize before you finally move to the US, well, you can do that. Just make sure you apply for a re-entry permit. So that way, when you're coming back to the US, you have your re-entry permit. The officer is not going to make it a big deal that you were outside of the US because you asked for permission ahead of time. The people that have an issue and will end up maybe losing their green card are people that do not ask for permission before leaving. Now, if you are already outside of the US, you're already past a year, 2 years, 3 years, 5 years outside of the US, and you want to come back to the US, but now your green card is expired, so you can't even get on a flight, what can you do? You can apply for something called an SB1 visa, a returning resident visa, with the embassy, right? All of this is done with the embassy in the country that you are in. You do have to show why you were outside of the US for that long, show things that are outside of your control. In order for you to get that SB1 visa, you need to show that it was outside of your control. And that's why you were outside of the US for that long. So situations where we have gotten an SB1 is for a child that was sent outside of the US and the parent took their green card, took their passport, and came back to the US. That child was able to get an SB1 visa because it wasn't their fault that they were outside of the US. They did apply for an SB1 visa and then COVID happened. So that didn't work. So now it's more time outside of the US. But because we were able to prove the reason that she was outside of the US, that it was because of a parent. It wasn't their own decision to leave the US because they were a minor. Because we were able to prove all of that, the officer at the embassy was able to grant her the SB1 visa, come back to the US, get her green card back. So it's not impossible. It's just harder once you're outside of the US for that long with an expired green card. Is going to be much, much more difficult. All right. I see a question. So, Paulette asks, my daughter applied for me last year, April 2023. How long does it take for I-130 to be approved? So you are outside of the US. Right now, a typical I-130 for a parent is taking anywhere from a year to a year and a half. Okay, so you still have, if it was filed in April, you still have a few months to go. Okay, but right now we're seeing about a year to a year and a half. All right. So the next thing that will definitely affect your ability to keep your green card is criminal activity, right? Some people will just say criminal convictions. However, right, according to immigration law, you don't have to actually be convicted of certain crimes for USCIS to use that against you, for US government to use it against you to try to take away your green card. So that's why I say criminal activity, not just criminal convictions. Convictions solidify the fact that you were involved in criminal activity, but having being suspected of criminal can be enough. Okay. Being suspected of criminal activity can be enough for the government to try to take away your green card. Now, let's talk about some of the criminal activities that could lead to you losing your green card. So, if you have a conviction for a drug offense, right? Anything other than 30 grams or less of marijuana possession. So, possession without intent to distribute. Okay. If there's intent to distribute, then that is considered drug trafficking. And it doesn't matter if it's less than 30 grams. Okay. Um, So it's really important that you stay out of criminal activity and stay away from people involved in criminal activity, because conspiracy counts as well, right? If you get roped into a conspiracy, or RICO charges or things like that, you could lose your green card. If you have a restraining order against you and you violate that restraining order. So in most states, a restraining order by itself is not a criminal offense. But if you violate that restraining order, it becomes a criminal offense. And because now it's a criminal offense, USCIS can use that against you. Assault and battery on a household member, or if it's labeled domestic violence, can also lead to you losing your green card. So there's a whole bunch of things that you can do that will lead to you losing your green card, when it comes to criminal activity. So you really want to make sure that you are staying within the laws of the United States and the world. Because if you have a drug trafficking charge outside of the US, that can also hurt you in the US. So it's not just criminal activity in the US, but it's in the world. Because anything that you're convicted of outside of the US, charges like that can end up, on your FBI background check, on Interpol checks, right? And now USCIS has that information and they can go ahead and try to take away your green card. So it is so important, like I said, stay away from criminal activities and you will be able to avoid this particular situation. The next thing that can lead to you losing your green card is if you had willful misrepresentation or fraud. This means you got your green card either through fraud or misrepresentation. So marriage fraud is the biggest one. So people that get married, not intending to actually be married to that person, just for green card purposes. And then they apply for citizenship, and USCIS is asking questions about that marriage that they got their green card through. And they can't even answer basic questions about the person, which leads USCIS to do investigations and find out, oh, this marriage was not real. Now they shouldn't have gotten their green card in the first place. So let's take it away from them. Okay. So just because you got the green card, right? There's people out there that may be, content with, they got their green card, they know it was fraud, and they just stay a green card holder. They do not try to get citizenship. But once you try to get citizenship, USCIS officers have the right to look at your prior marriage, right? They have a right to look at the reason you got your green card in the first place, and just reevaluate that and make sure they still believe that that marriage is real. And if they find out that that marriage was not real, they can try to take away the green card. Another thing is if you lied on an application. So let's stick with the marriage example. You filed a green card application with your spouse and you did not disclose that you had a child outside of that marriage. So you've been married for 3 years, you filed your green card application on the 3rd year of your marriage, but you have a 1-year-old and you did not disclose that 1-year-old because it was with someone that's not your spouse. Well, USCIS has a right to know about that child and has a right to ask questions to make sure that the marriage is real. So you keeping that information away from USCIS can lead to them questioning your relationship and lead to them trying to take away your green card. So it is so important that as you're filling out applications, that you are being honest and consistent with your information. Okay, that's why some people, when they come to me and they don't remember what they put on their green card application, they don't remember what they put on their I-130, we do a Freedom of Information Act request and get a copy of everything in their A file. So the A file is your immigration file. It's the file that U.S. immigration has on you. If you go to an interview at an embassy, they have access to that A file. If you go to your citizenship interview, they have access to your A file. If you got your green card in Massachusetts and you move to California and you have your citizenship interview in California, they have access to your A file. So when I say what's in your A file, we want to know that because it is what USCIS has on you, and they can use that if there's any inconsistencies to say that your relationship may not have been real or that you should not have gotten your green card. Another thing that people don't know, and I've seen this happen, is that you may not even know that there's an issue with your green card, right? Until you go to apply for citizenship. So I've seen this happen where someone will come, they were a derivative. So their parents got the green card. They're the ones that got the visa. They are under their parents' visa, but they entered the US before their parent did. So they got the green card, they got the visa at the same time. But then instead of the main person, the parent, coming into the US first, the child came into the US first, got their green card. Well, that's a problem. So if you are in this situation, you're getting your green card, your visa through your parents, right? Your parent is the principal applicant, right? Your parent is the principal and you are a derivative. You must come into the US either with your parents or after your parents, not before. If you come before the principal applicant, you're not getting your green card, and USCIS can try to take it away from you. Actually, they have the right to take it away from you because your principal applicant is supposed to come into the US first, and then you can get yours because, again, they are the principal applicant. So you cannot get a green card unless the principal applicant has their green card. So that's something that people don't think about, that I have seen shock people and cause them a lot of heartache and a lot of time in immigration court trying to untangle all of that. Okay, so that's another way USCIS will allege willful misrepresentation or fraud. There are defenses in immigration court depending on your particular situation. However, you want to avoid that by all means necessary. So if you're a derivative, come with the principal applicant or come after the principal applicant, never before the principal applicant. All right. If you are getting value out of this video, go ahead and hit the like button. Just let me know you are getting value out of this. If you have questions, please put them in the comments. I am more than happy to respond to you. All right. The next thing that is going to lead to you losing your green card is failing to remove conditions. So if you got your green card through marriage and you have a 2-year green card and you forgot to file to remove the conditions, USCIS is going to take that green card away from you and you're going to end up in immigration court. Okay, so you really want to make sure that you are, before that 2-year expires, that you are filing to remove the condition. Typically, USCIS will send you a letter months in advance of you reaching that 2 years to let you know, hey, by the way, you need to file a removal of conditions because we see that you have a conditional residency. So if you have not changed your address at USCIS, if you moved since you got your green card, please make sure you're changing your address because you have to do that 10 days, within the 10 days of moving. So until you become a citizen, you have to keep changing your address with USCIS, okay? Because you want to make sure that they're sending you any correspondence and you're receiving it. So 2-year green card, please make sure that you are actually removing the conditions, okay? Because that's going to lead to you not having your green card. So if you do not remove the conditions, USCIS has the right to terminate your residency and put you in immigration court. Sometimes people just are under the radar. USCIS does not follow up to put them in removal. That does not mean you're still a permanent resident. That just means they haven't went through the process. Okay. So traveling is out of the question because again, your 2 years has expired and you have not filed a removal of conditions. When it comes to the removal of conditions, USCIS is again checking if your relationship is real, if you have maintained, if they have enough documentation to show that you have maintained this relationship through which you got your green card, right? If they find that they don't believe that the relationship is still there, they don't believe that, you entered the relationship in good faith and maintained your relationship, well, they decide to deny your 751 application to remove conditions. And if they do that, they are going to terminate your residency. You're going to end up in immigration court, and the judge will get to make the final decision as far as whether your I-751 should have been approved or not. So, again, if you're getting your green card through marriage and you have a 2-year card, file to remove the conditions on time and make sure that you are presenting enough documentation of your relationship to prove to the officer that you entered into the marriage in good faith and you in good faith try to build that relationship. Even if you ended in divorce, that's fine. They still will want to see the relationship and the how you maintained your relationship since getting your green card. That's what the removal of condition is really about. Since you got your green card, what has happened, right? Did you get your green card on May 1st and file for divorce on May 2nd? Woo, that's a problem, right? So it's really important that you keep all of that in mind as you're going through this process. All right. And then the final way that people lose their green card is they voluntarily give it up, right? Some people, after being a green card holder for some years or months, they just like, I don't want to be a green card holder anymore. I want to go back to my home country. I am done with the US. So they will file a form I-407, and that is how they give up their green card. Now, some people will not even know what an I-407 is and go ahead and sign it at an airport and give up their green card without even knowing that they're giving up their green card. So, where does this happen? The people that have been outside of the US for way too long, when they try to come back to the US, sometimes the officers would give them an I-407, be like, okay, sign this and we'll let you go back home, right? And they'll go ahead and sign and they will voluntarily give up their green card. Okay, I've seen this happen. So it's really important that if you have overstayed outside of the US, right? You have your green card, you stay outside of the US for a year or more, and you're having an issue at the airport, please do not sign anything without understanding what it means. If it's an I-407, run, okay? Do not sign it unless you actually want to give up your green card, because again, that is a voluntary surrender of green card. You are not getting that back unless you have, family in the US or another way of getting a green card. You'll have to start the whole green card process over again. All right. So I'm going to be answering some questions. If you have questions, put them in the comments. Let's start with Michael A. Can a former asylee through social orientation, now a US citizen, marry the mother of his children and file an I-130 for her? Yes, but yes. Yes, you can marry the mother of your children as long as, again, there's no fraud involved, right? When you filed your asylum, you did not, you were not actually married to her. But as long as there was no fraud involved in getting the asylum, as far as she was concerned, yes, you can marry her, and yes, you can file for her. But just know USCIS or the embassy, if she is outside of the US, may have questions. Okay, but you are a US citizen, you can file for your spouse. All right. Sue asks, my child is 10 years old and undocumented, but he lived with his dad in New York. Can his mother, who lived in Florida, U.S. citizen, can I file for my child even though he doesn't live with me? Okay, so the child's mother lives in Florida and is a U.S. citizen. Can can the mother file for the child? That's how I'm understanding the question, even though the child does not live with the mother. Yes. However, it depends on how the child came into the US. If the child came with a visa, then yes, the mother can file an I-130 green card application for the child. I honestly, I have a lot of questions to be able to give you an answer. However, typically, if the child came into the US with a visa or with parole, the mother can file for the child because it's their child. Um, Even though they don't have the residency required, even though there's no residency with the child, that's not actually a requirement because if you really think about it, if the child was outside of the US and not living with the mother will still be able to file for the child. Okay. So it all depends on how the child came into the US, will determine how the process goes. So the mother may be able to complete the process in the US, or the child will have to go to a consular interview outside of the US. Because the child is 10 years old, they do not have unlawful presence, so they will be able to go to a visa interview outside of the US. But they should definitely get a consultation to just make sure the child does not have any other bars, you know, before leaving the US or filing any applications. All right. So remember, if you're joining me, you have questions, put them in the comments. I am just checking here to see if I have any questions on Instagram. I do not see any. Okay, perfect. So if you have questions, put them in the comments. If you've gotten value out of this so far, please go ahead and hit that like button for me. Thank you. All right. So I do not see any additional questions. Remember, ask me questions. I want to make sure that I get all your questions in before I go. All right. So that seems to be all the questions for today. So thank you all so much for joining me. We do these lives to basically give you information on US immigration and make sure that you are up to date on what's going on and that you are not only getting a green card, getting your citizenship, but actually getting to keep it, right? Today was all about how to keep it so that you don't lose it. So the first way is don't be outside of the US for a year or more without getting a reentry permit. Do not engage in criminal activity. Do not make any willful misrepresentation or fraudulent representation to USCIS or the embassy. Do not fail to remove the conditions on your 2-year conditional residency because you will end up losing your green card. And if you want to surrender your green card, you can do that with a form I-407. But if you are at the airport and want to actually remain a resident of the United States, you should not fill out that form. You should not sign that form because you're basically giving up your green card. All right. I see one more question from Pedro. Just got my traveling advanced parole card today. And what next? Pedro. So, what next is you can travel if you want. I'm guessing this is through a green card application. So, because I just answered this question recently for someone, your parole being approved and your green card application is not really, it doesn't make a difference to your green card application. It doesn't mean that your green card application is going to be approved soon. It just means that the parole is approved because they are handled by two separate offices. Two separate USCIS officers deal with the parole versus the green card. So one has no effect on the other, basically. The only time the parole and the green card have an effect on each other is if your green card is approved before your parole, then your parole application will be dismissed because you no longer need parole because you're now a green card holder. But yes, what's next? You keep waiting for that green card. You can travel outside of the US with the parole as long as you do not have anything in your immigration history that may affect your ability to travel. But if you're just a visa overstay, you can travel on your parole. If you entered, if you're just a visa overstay, you can travel without parole and you'll be able to come back to US. Again, everything being equal and nothing in your immigration history preventing that. Okay? All right. Hi, Lauren. I hope you are enjoying this. Thank you all so much for joining me. Thank you for all your questions. I truly appreciate it. I will be seeing you all very soon with more immigration updates. And if you are going through your own immigration journey and you want to work with me or get more information on the steps you need to take and how the whole process works, you can do that by scheduling a strategy session with me. You can go to my website, lilylegal.com, or call my office at 508-443-1788. Thank you so much. Bye.